Rosman. In this video, we're going to talk about what happens when you ignore a court order. My special guest today is Dan Rosman. Dan is a civil litigator in Toronto. He's been a guest on this channel many times before, speaking on the rules of civil procedure. He also has his own YouTube channel, which focuses on the use of technology in litigation. It's called Dan Rosman Legal Tech, so don't forget to check that out. So Dan, suppose you lost a trial and there's a judgment against you. So what can happen to you if you don't comply with the judgment?
Okay, well, first of all, thanks, Heather, for having me today. I always love being on your videos. So your question's a little broad, and we have to narrow it down a little bit, right? Because a lot of the times when we're in a civil case, we're fighting over money. Okay, so if you lose a trial and you owe money,
right,
what's going to happen is there's going to be an order for that money to be paid to the winner of the trial, right? So, and if you win a trial, you'll get an order that says the loser owes you some money. So let's say it's $1 million. You won $1 million, right? Now, hopefully, and to avoid further costs that the loser has to pay, they'll just pay you a check for $1 million and off you go. Okay.
right.
Now, unfortunately, that's not always possible. The loser might not have $1 million. So the winner has a few enforcement options available to them, right? The first one is to garnish that loser's wages, right? So you can get an enforcement order that says they owe this much money. You take it to their employer will deduct a certain amount of money from their paycheck. And I'll be honest with you, I don't remember the exact ratios right now, but there's limits to how much they can garnish. I think it's 20%, and 20% of that paycheck would then be paid to you every month. Okay, double check that number. It might be higher, might be lower. It might change since we make this video.
Okay.
Another option is to take money directly out of their bank account. Now, in order to do that, you have to know not just where they bank. It can't just be TD, Bank of Montreal, whatever. You have to know their branch. And you have to walk into that branch on the corner of 1st and 2nd Street and give that to your garnishment order or your enforcement order to the bank manager, and then they can deduct from the bank account. It's not enough to know exactly just their bank account number and whatnot, right? And then the third thing is a writ of seizure and sale, right? So what you can do there is you take your garnishment down to the sheriff's office. I'm sorry, you take your order down to the sheriff's office and you say, he owes me $1 million. I want to put this against his property or her property if they own a house or investment property or whatever it is. And then now all of a sudden you can recover from that property that they own. If the amount you're owed is big enough, you can force the sale of their property. If the amount that you own is not big enough, you're going to have to wait until they sell it, and then you'll get a piece of the sale, a piece of how much you owe from the sale. So those are the three sort of major ways to enforce a monetary award that's given to you by the court, or unfortunately, if it's made against you by the court, that's what we can do, right? When we originally started, I said, okay, there's the money order.
Yeah.
We can get enforcement. Okay.
Right.
Now I'm going to talk to you about a case. How about that? Can we discuss a case?
Yeah.
This case is called Paramount Fine Foods versus Kevin Johnston. And it started out as a defamation matter. Right. And Mr. Johnson defamed the owner of Paramount Fine Foods, Mr. Mohammed Faki. Okay. And all this stuff, it's not important for what we're talking about today, but he said all these terrible things. The judge found that it was defamatory, and the judge then made an order, don't say any more things that are defamatory. Okay. Now, Mr. Johnson did not listen to that order. So Mr. Johnson breached the order that the judge made.
Right.
So what now can Paramount Fine Foods do about this?
Yes.
Right? Well, so Justice Myers in this case that I've linked, that you're going to link for everyone.
Yep.
Said, well, you're going to jail. Right. So there's when the order that's breached is egregious or terrible,
Yeah.
which is what the judge found here.
Mhm.
They kind of switch it into a kind of like a criminal trial. When you breach the order, we're going to treat this like a criminal trial, and we're going to see what the appropriate sentence is, and we're going to see the appropriate proof that you did it. Now, if you remember, when we deal with civil law,
Mhm.
you win and lose on the balance of probabilities, right? So the judge just really has to think probably and most likely, this is what happened. When we deal with criminal, it's beyond reasonable doubt. I am 100% certain that you did this bad thing.
Mhm.
And the judge here found that he was 100% certain, or as close to that as reasonably possible,
Yeah.
that Mr. Johnson breached these orders.
Right.
And he reviewed the sentencing principles, and he reviewed the nature of the case and the nature of the things that this person did, and he went to jail. So the takeaway here for the purposes of our video today is, if you have an order to do something,
Mhm.
and if you flagrantly breach that order to the point that it's insulting to the court, and if you read this case, you'll see this Mr. Johnson insulted the court. He had a podcast or something like that, and he insulted the court, and he insulted judges, and he made it clear that he was not planning to obey the order and all that stuff. The judge said, "Okay, well, you're going to jail." And
So,
off
but
he went.
Dan, all right, that's a great example. So I would definitely include that in the link. But is it the court going out of the court initiating the process to get this person, or is it the party, the winner?
It's the party.
It's the okay.
It's the
So
party.
again, in the civil cases, it's really up to the party to enforce an order
Yes.
or judgment. Good.
Right.
Okay, that point.
And if that was if that wasn't clear, the test that the judge put, I mean,
Uh-huh.
analysis that the judge undertook, amongst other things,
Uh-huh.
was, included, did he insult the court? But really, what they were looking at here was Mr. Johnson continually to breach this order that was hurting the other party.
Right.
That was the real meat and potatoes of this, right?
Right.
And since he wasn't obeying court orders, and since he wasn't listening to, respecting the law, essentially,
Yes.
that was the remedy that the court found.
Okay. Just moving on to not the next question. You sometimes hear the phrase judgment proof. Can you just explain to people a little bit about what that means?
Okay, so we've already spoken about the difference between being owed money and fragrantly ignoring a court order.
Yeah.
Okay, so in the Johnson case, he was said, don't defame anymore, don't post about Paramount anymore, and he did.
Mm-hmm.
So he went to jail.
Mm-hmm.
Most of the time when you do these disobeying these court orders, what we really mean is they don't pay what they're supposed to pay, right? You're not going to get a judge putting someone in jail because they can't pay, right? So if I sue someone for $1 million,
Right.
and they don't have $1 million,
Right.
I've got a nice piece of paper that says they owe it to me. And I can go to their work and I can garnish their wages. And if they don't own a house, I can't do anything about that.
Right.
I can try to find their bank accounts and all those things. But what we say is you can't get blood from a stone. If there's nothing there, you're not going to get anything, right? And that's what people say about judgment proof, right? It doesn't mean that they don't owe it to you. And it doesn't mean that if they win the lottery tomorrow, you don't get to go take the money. But they're not going to win the lottery tomorrow. And they're not going to get more money.
Mm-hmm.
And they're judgment proof.
So speaking of which, do judgments have an expiry date? So let's say this again, like, you said you have a judgment against somebody and they're like judgment proof pretty much, right? They're poor. But let's say 10 years later, they win a lottery. Is that too late?
Judgments don't. So the Limitations Act, 16 sub 1 sub B, says a proceeding to enforce an order of a court or any other order that may enforce in the same way as a court has no limitation period. So that doesn't expire. However, some of the enforcement does expire. So you should double check if you're looking to enforce your writ My recollection is a writ expires after 6 years and you need to get a new one. And that may be the same with some of the other garnishment or something.
And this is all in the rules of civil procedure, right? This information.
Yes. Yeah.
Okay. Okay. So for our viewers, I will have to link on Canly to the rules of civil procedure.
Yeah. It's the rules. It's rule 60.01, which talks about all this enforcement.
So Dan, I think you mentioned that you have to know the judgment debtor's bank branch, but how did you find out this information?
So there's a lot of information that you need when you're going to try to enforce this stuff. So the rules of civil procedure, rule 60.18, it talks about something called a examination in aid of execution. Now, this is a process where you can, the rules call the creditor and the debtor. So the person who owes is the debtor and the person who is entitled to the money is the creditor. They can have an examination. And there's questions that the creditor is allowed to ask the debtor. So the rules say the reason, you can ask them the reason why they haven't paid. You can ask them income and property that they own. You can ask them about debts owed and all these things. There's a whole list and you can go look at it. It's like I said, rule 16.18, but that's where you get that information. And they're, under the rules, they have to provide it. And if they don't show up to an examination in aid of execution, then there's other enforcement issues that can arise, including jail and imprisonment and things like that. So it does get serious. Like, it does get serious. If you are a debtor and you are not, or are refusing to pay, and you have a real excited and motivated creditor, you're going to be in trouble. So you're going to want to avoid examinations in aid of execution. You're going to want to avoid contempt orders, like the one we discussed before, or with the Johnson and the Paramount case. The civil court does have the ability to come down hard on people that aren't obeying what they need to pay.
Right. So you can't just decide, oh, I'm not going to show up. I'm not going to show up for the examination.
You can't, and the rules will talk about that, what happens if you don't, and you don't really want to find out. You want to just go.